Good morning, and thank you for joining us on our webinar today. With me, I have Maria Scotland, the joint head of the family law team of 5 St Andrews Hill, and Jacky Lewis, an accredited and experienced mediator. I am Alison Green, head of the family relationship team here at Mackrell Solicitors, and I'm joined today by my colleagues in the team, Deem and Manisha Hurchurn. Have the next slide, please. Today's webinar will look at the difficulties that can arise with child arrangements over the Christmas and New Year period and how those difficulties can be resolved. We will be looking at what happens when separated parents cannot agree arrangements and how such issues can be avoided. There will be time at the end of the webinar for any questions you may have. Please use the chat function to put your questions to the speakers. If you do not want to share your question, then there will also be a poll at the end of the webinar where you can complete your details and we will contact you confidentially after the webinar. As we all know, unfortunately, we are in the midst of a second lockdown with the current restrictions due to be lifted this week. We're all waiting to see what we will be allowed to do over Christmas and the New Year period after the vote in Parliament today. Irrespective of people's personal, religious or cultural beliefs, the Christmas holiday period is usually a magical time of year for most families and especially children. People look to relax together, spend time with each other and celebrate and look forward to the fresh new year. And that is never more the case than where we find ourselves at the moment. For separated families, this is a time when parents need to agree the arrangements for their children and where they spend time between separate households and seeing members of their extended family. In the absence of agreement, people quite often turn to us and seek help and advice in reaching these arrangements, fairly frequently through mediation or the court process. We have seen a huge spike in the number of parents needing help and advice over this period. More often than not, this is on an urgent basis, and in the run-up to Christmas, we have to consider how these matters can be dealt with. It is our concern that these numbers will increase yet further, because unfortunately COVID-19 has impacted families in that tensions have increased with a distinct lack of cooperation in co-parenting rather than greater cooperation that one would normally expect. This may be sadly because we have seen many parents who have been willing to abuse the current crisis and use it as an excuse not to be cooperative over child arrangements and to renege on prior agreements or court orders for payments of maintenance and other support. Can I have the next slide, please? As we all know, there are various rules which apply to the devolved nations, and my colleague Manisha will now take you through those.
Thanks, Alison. So yeah, we thought it would be useful to run through the restrictions in the UK at the moment and how that might interplay with child arrangements over the Christmas period, because they are quite complex. Obviously, each nation is running to its own rules, so something to think about. So let's start off with England. So as we all know, we've been in lockdown 2.0 since the 5th of November, and we're due to come out of that just after midnight on Wednesday, the 2nd of December, so tomorrow. When we do come out, we will be all subject to 3 different tiers. So tier 1 will be medium risk, tier 2 will be high risk, and tier 3 will be very high risk, so the danger zones. And in those 3 tiers, obviously, the restrictions go from obviously medium to very high. So we're all working towards different rules and regulations up and down the country as of tomorrow. So what's happening in Scotland? Well, they're already operating a 5-tier system, again, 1 to 5. And in the most high risk tiers, you can't travel in and out of those areas. In Wales, they did come out of a lockdown last month, but it was announced yesterday that they're going back into a specific kind of a lockdown on the 4th of December, mostly in relation to restrictions on hospitality. So there'll be a ban on alcohol being sold in pubs, restaurants, cafes, and they all have to close at 6. In Northern Ireland, they are currently in the midst of a 2-week circuit breaker, which ends on the 11th of December. And obviously, the rest of the world is operating and implementing different rules, regulations, and laws on a daily basis. So, you know, if you do have a situation where your normal child arrangements over Christmas involve travel out of the country, abroad, out of the UK, then, you know, please do check the government website in relation to the travel corridors and what you can and can't do, and what countries will, you know, require you to quarantine, or whether you have to quarantine when you come back. So a little bit more focus on England. And I think what's most relevant to us talking today is that across the 3 tiers, children can move between the homes of their separated parents. And if you want to look at that in more detail, it's on the government website. And what might be relevant to some of you is the rules where it says the exceptions to restrictions on gathering. So this falls under all of those exceptions, and the actual wording says, for arrangements where children do not live in the same household as both their parents or guardians. For some of you, these others might be relevant. So to allow contact between birth parents and children in care, as well as between siblings in care, and for prospective adopting parents to meet a child or children who may be placed with them. So if you want to look at the full guidance, it's on the government website. I also wanted to touch on Wales, because obviously the jurisdiction we deal with is England and Wales, but obviously they're devolved nations, and Wales is doing its own thing separate to England in terms of the rules and regulations. At the moment, there is a sort of travel ban between England and Wales, but that ends when we come out of lockdown in England. However, note that Wales goes back into a specific lockdown on the 4th of December, so 2 days later. And because this was only announced yesterday, I'm not 100% as to whether the travel ban will be reimposed from the 4th of December, but something to keep an eye on if you are dealing with families between England and Wales, or indeed, you know, court orders under that jurisdiction, because that will become relevant. What's most important for this is obviously the Christmas rules, and what I'm going to refer to as the golden period of the 5 days between the 23rd and the 27th of December, where the devolved nations have all come together and unified, and they will allow travel between the 4 different countries, and you can form a Christmas bubble with up to 3 different households, but it's only for those 5 days, apart from Northern Ireland, I think, who have added on an extra day either side to account for travel time, so you don't miss out on the actual quality time of the 5 days with your family over Christmas. Now that's just a run through. There is minutiae to this, so depending on the individual circumstance and situation you're dealing with, please check all of the rules, the regulations, go onto the government website and see what the guidance is, because for a lot of these breaches there are now fines which are being imposed, and they can be quite hefty, so double check and triple check.
Great, thanks Manisha. Can we have the next slide, please? So Jim, bearing in mind everything that Manisha's said, how has COVID affected children arrangements generally?
Well, I'm kind of, when I was sort of preparing for this, I was thinking about the Matt Lucas skit about the rules, and you can, you can't, you should, you shouldn't. I think the thing for me is that the rules themselves are quite difficult to understand, and they change. And I think what we've all seen as family lawyers is a willingness to be very pedantic if it suits, and to be quite flexible if it suits. So in other words, this issue is exactly the same as any other issue that we deal with in family law, namely that much will depend on the attitude which individual families take and individual parents take to the situation that they find themselves in. And so reasonable people will make sensible, reasonable arrangements, and those on the unreasonable end of the spectrum will use rules and well-being as a sword. Others will use it as a shield, and it's very difficult really to take any sense out of that. All you can say is to look backwards and say, well, what have the courts done so far? And what the courts have done so far is to prioritize the relationship between parents and children who live apart, and to look at them on a case-specific basis and determine the extent to which there is actually some justification in changing court orders, for example. And I think there's a big distinction here between those families who are living with a court order and those families who have made arrangements informally, perhaps between themselves, and now want to crystallize those into something different. Because if you're in the category where you have a court order, then frankly life is much more straightforward, and judges have shown a preparedness to cut through the excuses, if they be excuses, and look at the actuality on a case-by-case basis. That's, I think, the experience that everyone on this webinar has. So it really does depend, like very much everything in family law. It depends on the situation you're in. But if you're in the unfortunate situation of not having a court order and struggling to make arrangements for Christmas, this coming Christmas, and it's already clear to you that there may be issues, and if there are distances involved, which could involve booking airline tickets and whatever else that may be involved, then really the thing to do is to act very, very quickly, because time is of the essence, and trying to get something before a judge at this stage will be challenging. If you have a court order, I would suggest that you do the same thing, but you're more likely to get a positive outcome. But either way, I think planning is key. And in my experience, courts have been prepared to look at what's right for this child in this situation, and not be reticent about saying these arrangements must prevail, because it's in the interest of the children to do so. But you can really see, given the situation that Manisha's described, where it's yeah but no but yeah but, it allows a margin of maneuver which can be malign, or it could be very well intentioned. It depends. So in my view, you should speak to a lawyer sooner rather than later to get an overview about where you are and what you can do, and act quickly.
Okay, can we move on to the next slide, please? Jacky, with all of that in mind, obviously we've got a short period of time between now and Christmas, so presumably if people think they can work things out, mediation would be a good option.
I would say, good morning everybody, I would say the advantages of mediation in these situations is you can organise it quickly. It's a confidential space, it's without prejudice, so whatever we say in the mediation room cannot be taken on to court. People have a voice, and as Jim says, really, it's never about what it says it's about, it's always about something that's driving it, because if there was not emotions driving this, then the parents would just agree. So there's some reason why there's a disagreement here. We try to mediate so we avoid blame entirely, and what we do as mediators is try to get parents to realise that they are 50% responsible for whatever's happening, and blame doesn't help anybody. Obviously we're much cheaper than going to court. What I would do is have a 1-hour private intake with each parent, completely confidential, and then a 2-hour joint meeting. Usually we can settle things there, and if things are particularly entrenched, sometimes we get presented with really high conflict parents who are never going to settle, because the fight is everything, and what they don't understand really, from my perspective, is there are no winners and there are no losers. The only real losers are the children, who love them both dearly and are 50% of each of them. We try to address power imbalances in mediation, so we sometimes have a very vociferous one party and a very timid other party. We try to address that where we can, but in situations where there's been a history of domestic assault, we try to avoid. We used to avoid mediation in one room, obviously. Now, if both parties agree, if the assaulted, if we can say, party agrees, then perhaps on Zoom it's not so threatening. I have done 1 or 2 shuttle mediations, which means I see parties separately. It's not very successful in that you end up as a mediator, as a sort of messenger girl, taking things back and forth. But if you've got issues with children over Christmas, I would say that mediation is your best case scenario, just in the children's best interest, which is what we're all working towards, really. Thanks.
And Maria, if mediation doesn't work, or things are just not going to be able to be resolved through mediation, how do the courts deal with things?
Well, I'm going to bore you a little with the law, because it's important to have an insight into why a judge makes orders before telling you a little bit about the orders that the court makes. The courts derive their power to interfere in personal lives of parents and make orders regulating their children's lives under the statute called the Children Act 1989. So it's an old piece of legislation, it's 31 years old now, but it's still good law. But it has been amended and updated. 6 years ago, it was updated in 2014 to change the terminology. We used to call orders regulating children's living arrangements and time they spent with their parents, residence and contact, and we now call them child arrangements orders. And what that sets out is, or what the orders that governs is, with whom a child should live and whom the child should spend time with, and the periods. And so it's important to know that. It's also important to know that 6 years ago, so in 2014, when the Children Act was amended, it was also amended to introduce a very welcome section called Section 11, which establishes a presumption that every child's welfare is bettered, furthered by involvement of both parents. And that's a really good starting point. So what it's important to know is that the courts look upon all applications for child arrangements orders, as they're now called, on the basis that every child in the case, so if there's one child or more than one child, will benefit from spending time with both parents. And so what does that mean in plain English? It means that the courts will presume that unless there are fact-specific reasons that where parents can't agree the time that their children spend between them over Christmas, the judge will make that order and presume that the child will benefit from sharing their time between both parents over Christmas. What sort of allegations, what sort of facts would displace this presumption? Well, that really is allegations of domestic abuse, often addiction issues, or else mental health incapacity. So where the courts receive an application for a child arrangements order, such as we've been talking about over Christmas, parents can't agree what time their children should spend between them, the courts will start from the presumption these children should share their time between the two homes, and they're looking to see, they're asking whether there is any reasons why not. And the Courts of Appeal have considered the interplay between this presumption and allegations, and Lord Justice McFarlane has set out that the statutory default position, so the starting point, as I said, is that a parent is not to be treated as a risk of harm to a child unless there's evidence before the court, and that evidence has to be tested and as swiftly as possible, and by having a fact finding. And then, so if the court then, if there is no fact specific reasons why a child should not be spending time with the other parent, how does a court then decide what orders to make? Well, the court we look back to the 1989 Act at Section 1, and this has never been amended or updated. There's a Section 1 sets out what's called a welfare checklist. And what this is a list of facts that the court looks at in every single case, no matter the circumstances, and goes through that list. There's a list of 7 factors that the court considers in every case. The first and most important factor that the court considers is the wishes and feelings of the child. In other words, what would the child say? But those wishes and feelings are considered in the light of the child's age and their ability to understand what they're saying. The court also checks to see whether what a child is saying is actually what they feel and not what they picked up from their parent and is repeating. Again, that will be fact specific. They also look at the child's emotional and physical needs in cases where there are special needs. It may be that there's very special circumstances, but generally the courts will look through those welfare checklists, those list of factors, and then decide what arrangements are or should be made in the court order on the basis that these children will benefit from spending time with both parents. So what orders do the court generally make? There's no real case law setting out hard and fast rules in every case, but as a rule of thumb, the courts tend to divide up a child's year into school term times and school holidays, and they work toward where the child's over 4 years old and is therefore at school. And then they work towards a pattern in an order whereby the child will share their school holidays between the two parents, and they'll alternate weekends during the school term time between the two parents. So where we're talking about Christmas, generally, if the child's of school age and they've got good relationship with both parents, so they know both parents, the courts will look to divide the Christmas holidays in two. So that would mean for state schools, 1 week with each, and with private schools, 2 weeks with each. And we would generally alternate Christmas between the two homes. So in cases where you're making an application concerning Christmas around about now, the courts would look to, and what you should expect and anticipate is that the children may well spend Christmas with one parent, and then they would generally spend the new year with the other parent. So if you're spending Christmas with one parent, you'd look to pick up, say, on Boxing Day or soon after. If the child's younger than school age, then generally it would be dependent on their age and their relationship with the parent. If it's a nursing baby, it might be that the parent would only spend a couple of hours with the parent, and but if it's slightly older, it might be it would spend less. The child would spend less than a whole week with the other parent, but maybe a couple of days overnight. So that gives you a general idea about how the courts deal with these.
Okay, that's great. So Manisha, from a procedure point of view, what needs to happen?
Yeah, so following on from the, really thorough explanation there from Maria, in terms of the law, there isn't a specific provision that deals with, Christmas contact or child arrangements over the Christmas period. So in relation to if you are having to make court applications, you're using the same standard forms that you would, if you were applying for a child arrangements order, or, a specific issue or something like that, or perhaps a prohibited steps order, because that might also come into play during this time. So you're using the standard applications, and it might be that you already have existing proceedings for child arrangements in which you make an application within those proceedings, or it could be that you're having to just deal with this as a freestanding issue, so you're making the application from fresh. I think what we've all touched on so far, and what might be relevant given that it is the 1st of December, so it's Christmas in my book now, if you are having to all of a sudden litigate on child arrangements for whatever the reason, you can do that on an urgent basis. Like I think Jim said, Maria's touched on, you're going to be hard pressed to try and get something before a judge in time, especially depending on when the child arrangement starts. If it starts from the end of, the school term, so the 2nd week of December. But it is possible. You can make an application on an urgent basis, but do bear in mind that what the court deems urgent might not necessarily be what you deem urgent. And, if you have created the urgency because you haven't done advanced planning, or you just didn't think, it would be a problem, that is not necessarily what the court is going to agree is something urgent and what the court needs to deal with. So, urgency is more along the lines of, there is an agreed plan, you've paid for bookings, travel tickets, maybe accommodation, something along those lines, and then the other parent is reneging on that for no good reason. A court is likely to agree that that is something urgent that they will want to try and help you with. So just assess what's going on, and if you're having to go to court because mediation hasn't worked, you've spoken to somebody like Jacky, that's not moved it along. You've spoken to, lawyers, you've spoken perhaps to Maria, and you know, initially those negotiations haven't worked, clearly if it's an urgent situation you're going to have to make the court application, but it will follow sort of the standard process of applications, except if there's an urgency and you're going to have to persuade, number one, the court staff to list it for you on an urgent basis, and good luck there. And secondly, you're then going to have to persuade whichever judge you come before, perhaps on a remote basis, which might be an avenue to get an urgent hearing, because you don't all have to turn up at court and use a courtroom. But yeah, bear all of this in mind. That is the procedure, but you have to assess whether the situation does actually need to go to court for Christmas.
Okay, so can we move on to the next slide, please? Because feeding into all of this is something called parental alienation. And as I said at the outset, quite often parents at the moment are using the current situation to alienate their children from the other parent. Jim, do you want to explain a little bit more, please?
Yeah, surely. Okay, so parental alienation, there's a clue in the title. It's a situation in which one parent is alienated, that is, they are essentially removed physically, psychologically from the life of a child. And crucially, this is not based in their actions or their behavior or some other quality relating to them. So there is no domestic abuse, there is no mental health problem, there is no substance misuse. There is just a sort of existential dread on the part of a child spending time with the parent with whom they don't live. And it can't be explained by the things they've said or done. Or allegations are made which are subsequently shown to be not proven, and yet still the parent who made the allegations, perhaps on behalf of their children, maintains that they are actually facts. And I don't care what this judge says at a fact-finding hearing, he or she is, you know, out of touch with my children. So it's a situation in which the kids are essentially saying one thing, but may very well be feeling something quite different. And what this tends to center on are perhaps probably older children or children who are capable of articulating to some degree their wishes and feelings, which the other parent simply doesn't understand. Now, CAFCAS have a definition. They have a lot of information on their website about how to manage this situation. And it's something which I think has become far more prominent in the last few years as a result of the changes in the Children Act, which Maria highlighted. So there is no longer a case you have to prove why your children should spend time with you. It is assumed. And in a sense, the burden has to shift to the other party to show why that shouldn't be the case. And so these issues are becoming more and more frequent in their occurrence. But the definition which CAFCAS has, and I'll read it to you, and this is from their framework assessment document: when a child's resistance or hostility towards one parent is not justified and is the result of psychological manipulation by the other parent. Now, the framework document and the notes which accompany it, including a 15-page summary of the various manifestations of this, explain that this isn't necessarily one parent being malign entirely. It's not a seesaw whereby the virtuous parent is left dangling with their feet in the air and the other parent is, you know, firmly on the ground. It can often be a mixture of hostility between parents, which one parent then takes forward. But more often than not, both parents are responsible to some degree for the situation that arises, and which is then called parental alienation. So there are various mirrors that people have to look in to answer the question as to why their children are responding as they are. And sometimes that's uncomfortable. If you suspect that this is occurring in your life, then I think this is a situation which really is going to be subject of professional assessment. Perhaps, but Jacky can also speak to this. I think maybe we can pick this up under a question. It's something which may well have to be resolved in the court forum with the involvement of CAFCAS or an independent social worker and adjudications, findings of fact by a judge, in order to actually set a factual matrix upon which orders can then be made. Because these are the more extreme cases in which all relationship between children and parents can break down. And ultimately, and I've acted for children myself in this context, it may well be that the children have to be separately represented because the interests of the children are being lost within the parental dispute. So I've in the past acted on behalf of children in these situations where their parents are essentially at war through the court process, and one is alleging alienation and the other is alleging all manner of things. So these are very difficult cases, ones which require professional input, not just from a lawyer, but from other resources such as independent social workers, psychologists, and CAFCAS.
Okay, so if we move on to a slightly different tangent in terms of what's going on right now, clearly the pandemic's had a massive impact from a financial point of view. It's caused a lot of problems for families in terms of child support. Many people have been furloughed or made redundant. So Manisha, in terms of financial support for children, how is this regulated when parents separate?
Yeah, so, you know, as you've said, obviously one of the worrying issues facing many separated families at the moment is finances or lack thereof, and in particular, cessation of payments from one parent to the other parent, especially during this period. You know, it becomes very tangible, it becomes very real to them. So Christmas is generally a time anyway when more money is spent during the holidays than any other time of the year potentially. So it can become really difficult if one parent is sort of holding the other to ransom by failing to make payments for children, so child maintenance, etc. And the other parent is desperately needing that money, you know, especially this month in the run up to Christmas and trying to plan. So it becomes really, really important. And what we have to remember is that, you know, more than adults, Christmas is a time for children, and you know, it means so much to them in many different ways. And when you think about that element, you know, against a backdrop of parents feuding over financial contribution to make Christmas a nice time, it becomes really sad. So first point of call is to consider child maintenance being paid and how is that being paid. So if it's being paid by agreement between the two parents, then that's absolutely fine, and it's, you know, something that's to be encouraged. If it's being done through the Child Maintenance Service, which is the government body tasked with dealing with child maintenance where there are issues and payments have stopped, then obviously you've got to take that through the Child Maintenance Service itself, give them a call, keep on at them, because I know it can be very, very difficult to get through, to speak to someone or to have someone contact you. So, you know, unfortunately, the onus is on you to keep on at them so that you can communicate what the problem is. But if that is what is happening and payments have stopped, you must do something about it, and you can do something about it, especially during this Christmas period. So child maintenance, number one, are you being paid it? Has it been stopped? If so, why? Open up a line of communication. Maybe it's something that, you know, Jacky can help with in terms of mediating what the problem has been. Why has there been a breakdown in communication over it? More than likely during this pandemic, there's, you know, going to be a really good financial reason as to why payments have potentially stopped, but perhaps the communication between the parents isn't the best. So that can be communicated properly and an alternative put in place, even if just for the interim. So that deals with child maintenance generally and on the whole. But there's also something else that can be explored, which is another court application under the Children Act called Schedule 1. And that is for scenarios where, for instance, the parent is already making the maximum maintenance payment in accordance with the child maintenance caps, but they can afford to make more. And if they can, then, and if it benefits the child, then why not? So you can pursue that under a Schedule 1 application, and it will be a top up of the maintenance that's being paid through the CMS. But that application can also help parents who, are struggling to provide adequate housing for the child. And do remember, an application under Schedule 1, all of those provisions are for the benefit of the child, not for the parent with whom the child lives. So, it can help the parent to provide adequate housing if the other parent has that resource to hand. And it can help with debts that you've accrued, in basically expenses for the child, so just raising that child. It can account or provide for a car if you need a car to drop your child to school every day because it's quite far, etc. But as I've said, it's all for the benefit of the child. So these orders run until the child is an adult, usually 18. So in a case where you might have a house that's been made available for the benefit of the child, and you're also living with that child, it will revert back to the other parent if the parent owns it, or the parent, will stop making rent payments. So I think over the Christmas period, which is what we're talking about, if you're faced with any of those sorts of situations, as we've said, trying to get a court application in urgently might be a struggle now, but especially in relation to child maintenance, if those payments have stopped, that needs to be explored. If there's a good reason, then okay, it's out of everyone's hands, but there needs to be sort of an interim arrangement put in place, because at the end of the day, what we all need to try and focus on is making Christmas a beneficial experience for the children, as best we all can. So it's a conversation that needs to be had.
Okay, that's brilliant. Can we move on to the next slide and actually just drawing Jacky in on that? Jacky, how can you help with the financial problems that actually arise? I think you're muted.
I was just listening to Manisha. It was really interesting about how you can help. Money's a metaphor, really, in my world. What does it stand for? Well, it stands for, I don't know, can stand for punishment, revenge, despair, attack, all sorts of things. And as we said before, the only losers here are the children. I think the idea of being able to see a mediator quickly, often sometimes the parents that I've seen haven't been able to speak to each other in any adult manner for months or years. So they haven't had the dialogue about why one parent has stopped or reduced the payments to the other. It could be that they've lost their job. It could be a communication to the other party. It could be many, many things. And until we talk about it, we won't know. It could be if things are very, very difficult financially, there is a top-up available, perhaps. Granny, grandpa, uncle could step in a short-term way, which we could explore in mediation. As I say, it's a confidential process, so it's a process to explore. And what's particularly helpful is the private meeting we have with each party at the beginning, so we really can get their perspective. The other thing we can do in mediation, which we haven't talked about, is for mediators to see the child, to hear its wishes and feelings. Now, mostly the child will say, I wish they'd stop fighting. That's what usually comes up, but we do offer child inclusive mediation, which is a completely confidential process to the child. And we follow it up with a parent's feedback meeting afterwards, but only feedback, that material which the child expressly asks us to do. So there may be some material the child does not want us to tell the parent, but feels better having shared it with the mediator. But the only victims here, as we know, are the children, and there's some reason why the money is stopping, and it's good for the other party to know and for both parties to be able to talk it through in a timely manner.
Thank you. I'm going on to the next slide, Maria. What about the court's position? What can they do to assist?
Well, there are two different categories or types of applications that can be made for financial orders. I'll deal first with the types that concern children. So applications for financial orders in respect of children only. And Manisha touched on that when she talked about Schedule 1 of the Children Act. So the Children Act is the act that I talked about before, the 1989 Act, and under Schedule 1 of that Act, it sets out the orders that the court can make, financial orders in respect of children. So one parent rather, can make an application to the court for financial orders for the benefit of their children. But there is a limit to what applications can be made and what jurisdiction the court has, and that limit is fixed by the Child Maintenance Service. So the Child Maintenance Service is the government body which deals with maintenance payments from one parent to the other, and it's usually the separated parent to the primary carer of the children. And the Child Maintenance Service assesses what payments should be made, should be paid rather, by the paying party, usually the separated parent, to the primary carer. And there's a formula for that, and the formula is governed by the gross income, weekly or annual income of the paying party. And that's usually assessed by asking for proof of income, which is usually a P60 or tax return filed annually. And the reason I'm labouring this is because the court's jurisdiction only comes into play where the Child Maintenance Service has reached what's called its maximum limit. So the Child Maintenance Service has jurisdiction for those parents who earn up to a maximum of £3,000 per week or £156,000 per year gross. Anything above that, that person then becomes a maximum earner as far as the Child Maintenance Service is concerned. And then the family court has jurisdiction and acquires jurisdiction for making payments, for making orders of periodical payments, so child maintenance, above that maximum award. So what's called top-up payments. So the Schedule 1 of the Children Act is an application which can be made seeking top-up payments. So the other party, the other parent, has to earn over £156,000 a year. There are other orders that can be sought under Schedule 1 of the Children Act, apart from periodical payments or child maintenance. And Manisha touched on this quite briefly. You can make an application for either a lump sum or a transfer of a property outright to you to provide for your child's housing need. So if you're in a situation where you don't have sufficient capital, you don't have a property in which to house your child, but the other person does have capital or property available to them, so they're wealthier than you, then the court can redistribute their wealth in order to provide housing for that child, so long as the child is a minor or in education. So a house that's transferred would be transferred back, in most cases, to the person who's providing that money or that housing when the child is complete education, which is either 18 or 21. And then you can also seek payments of lump sum for other needs of a child, including educational needs. So that's the application that can be made. Now, don't labour under any misapprehension that this is an application that can be made urgently over Christmas when money's tight and the other person stopped payments, because the application process through the courts is such that you make an application on what's called a Form A, and then the court requires both parties to complete a form which sets out full disclosure of what their monetary and financial worth is. So in other words, how much are you both worth? And then the court compares and contrasts how much does the person who the children live with need, and then the affordability. Can the other party, does the other party have enough capital and income resources to meet that need? And if so, what orders should be made? So the process involves disclosure by both parties on Form A, and then there's usually 2 hearings that follow, and potentially 3. The first hearing is what's called case management type hearing, when the judge looks at the disclosure and considers what other evidence or what issues have we got in this case, what evidence do I need to get me to the second hearing. And the second hearing is called a financial dispute resolution hearing, or an FDR, and that's when the judge acts as a mediator, but it's a judge who is again a without prejudice hearing, and the judge tries to assist the parties to reach an agreement between them by indicating to them what he or she feels is a fair and appropriate order. So there's 2 potential hearings. It takes at least 6 months of court process for you to get to that stage from issue to FDR, and actually 6 months is the usual court process time pre-pandemic. During the pandemic and into the future, you probably should add on another 3 months upwards, or potentially more in certain areas. So it's not an application that can be made for seeking urgent relief, and so I laboured that. Nonetheless, you can make that application now, looking to the future, particularly if things are tight now. There are urgent applications that can be made for finances, but they're not ones where you haven't been married to the other party and you're making your application under Schedule 1. If you have been married, and this is the second type of application they talked about, I very briefly touched on because it's a whole different webinar of its own. If you have been married to the other party, or you're in the midst of a divorce, you can seek financial orders for yourself and your children in the divorce. If you've got a financial order and the other side is breaching it, so that's why you're in so dire straits over Christmas, you can make an application for enforcement of your previous orders on a D11. And there are potential circumstances where the court would hear that urgently. But as I think we touched on earlier in the webinar, we're at the 1st of December, even trying to get an urgent hearing before the courts, you've really got to get your application in now. So there are 2 different kinds of applications, but unfortunately the bad news is that you're unlikely to be able to get anything dealt with really swiftly and in time for Christmas.
Great, okay. We're going to move on to questions now, but before I do, just a reminder that there will be a poll popping up on your screen shortly. And if you do want a confidential chat or exchange with any of us, then do please fill that in and we'll come back to you as soon as we can. So we have had some questions come in. The first one I think is probably for Manisha. I will be in a tier 2 area after today, and my ex will be in tier 1. Can our child still spend time between our 2 homes?
Yes, so the guidance does say that children can move between the homes of their separated parents across all 3 tiers, so that should be completely possible and okay. The only thing I think you need to watch out for is if you're moving between tiers, when you're in another tier, you've got to abide by the rules and restrictions of that tier for as long as you're in there. Sounds like prison, but you know, just bear that in mind, because I don't know if it's just a handover or you'll be there for the whole day. Obviously, you need to check what the rules are in terms of going into restaurants and etc. But yeah, that's fine.
Okay. What would the court deem urgent for a Christmas contact application? Maria, is that something you can help with?
There are limited circumstances. It would have to be, so urgent would mean, say for instance, you've booked a holiday with your child, it's previously been agreed with the other parent, and then they've decided, they've changed their mind for whatever reason. They didn't like your new girlfriend, they found out you're going somewhere really swish, they're jealous, whatever it may be, or something more serious. So you've got tickets booked, you were expecting to pick up your children together with their passports, or if you're staying in the country, you were hoping to pick them up and take them off on holiday, and suddenly they've gone quiet, or they blankly refused. It may be that that type of application would be heard by a judge. So what you'd need is evidence of prior agreement, then no good reason, welfare-based reason for sudden change of mind. Perhaps you've got bookings. So if money's spent, and there's an agreement, that's the kind of thing which a court is likely to deal with on an urgent basis, because it can be dealt with in an hour, possibly 2-hour hearing by a judge on the basis of evidence, and a judge can be quite certain that the orders he's making are there in the best interest of the child, and that he's not doing something which the other parent had previously agreed to. The other reason, sort of things that might be urgent, is if you get wind of the fact your child's going to be taken out of the jurisdiction and you haven't agreed to that. So you're seeking an injunction to prevent something happen, rather as the other type of order you are seeking an order permitting something to happen, or anything where a child is at risk, then that would be considered urgent. And they're quite easy to make those types of applications. The courts now accept applications online, and they'll be dealt with by a judge.
Can I just come in on that? I had a situation over the summer where a client who I'd acted for some years ago, and we'd agreed an arrangement much against the wishes of the other parent, and the part of the order was to take the children to abroad on holiday, and she was throwing the COVID bombs in our direction, and he re-instructed me, and the courts were prepared to treat that as being an urgent matter. In exactly the situation that Maria's just explained. Tickets had been booked. I think he stood to lose about £4,000 or £5,000, and some very stern correspondence to me, to the other party, and at the same time issuing the application resulted in the children being handed over when they should have, according to the terms of the order, without us having to actually go to the hearing which had been listed. So sometimes, it's the old Theodore Roosevelt aphorism of talk quietly but carry a big stick. So she knew we weren't mucking around and we were going to go to court. And she knew also that the courts were prepared to deal with this. And so he had the sense to instruct me in good time, and his children went on holiday and had a great time with him. So.
Yeah.
Great, okay. Jacky, someone has asked, how do I go about instructing a mediator, and do I need a solicitor to do that for me?
Okay, so you don't need a solicitor to do that for you. You can instruct a mediator directly. I would suggest to everybody that they have a solicitor in the background to hold their hands, just have a bit of legal advice from. But no, you just come straight to a mediator.
Okay, brilliant. Okay, here's an interesting jurisdiction one. Can I apply for a child arrangement order in London where the mother of my child has moved to live with my child in Scotland and is not wanting me to engage with her or allow me to see my child? Manisha, jurisdictionally, what would be the best option?
Yeah, well, if the child is habitually resident in Scotland, I think, you'd have to launch proceedings there, because the English courts, don't have the right to make decisions about that child. So you'd have to figure out habitual residence. When did they move? Has that child acquired habitual residence? It's not as straightforward as it might seem on the face of it. But yeah, of course, you can still launch proceedings in Scotland. You would just have to take the legal advice there and follow the procedures there.
And the position there is very different in terms of law. We ought to be clear about that. And that's why we're only qualified to advise on law in England and Wales rather than in Scotland.
Exactly.
Yeah, okay. Jim, in what situation should I go to court rather than mediate?
Okay, you should go to court if, I suppose, the dynamic possibly between you and the other party is such that you don't consider mediation would be appropriate. But I think in that situation, rather than take an old curmudgeonly litigator's view, you should speak to a mediator and allow them to have a view of the situation and determine whether or not, in their judgment, this is not something that can be mediated. I think the only other situation where I would say categorically is perhaps where there's such a high degree of urgency in the type of injunctive type children orders, where you're trying to prohibit someone from doing something, removing from the jurisdiction. In that sort of situation, or perhaps an internal relocation where someone's saying, I've decided that I'm going, to return to Portsmouth with my kids to my homeland, and you don't fancy that. In that situation, it may well be that just getting a prohibited steps order is a much more effective route. But I think in other situations, I think it's case dependent, and there are no hard and fast rules. It depends. I think, in my experience, if you get a sense that the dynamic between the parties might be a bit dodgy, then it's something to explain to a client. But I think also, as has been said, they aren't necessarily, lawyers and mediators aren't necessarily mutually exclusive. Frequently, we work in parallel, and using a mediator and having a solicitor in the background to advise you about the law is not inappropriate. So I don't think it's binary. It's necessarily one or the other. It's, well, horses for courses, frankly.
Can I just come in here, Alison, to say briefly, I often co-mediate with lawyers and it works really well because we have different hats on. In fact, I'm doing one at the moment. I'm doing the child aspect of it, and she actually is doing the financial aspect. So it can dovetail too, as Jim is saying.
There you go.
Yeah.
Okay, and we've had a couple of questions about costs of mediation. So firstly, if I'm the person who wants to go to mediation, do I have to pay for it?
We would urge you very strongly to share the cost of mediation just occasionally, and I've got one on the boil at the moment. One party will not contribute a penny even after my urging of put £20 in the pot. They just think the other side is such a bad person that they should pay for everything. It's not the best. The best is to just share everything equally.
Okay.
In the spirit of mediation.
We've just had somebody say, I think the sound is lost. Can everybody hear?
Yeah.
Yeah.
Yeah, I can hear everyone.
Okay. And also the other question is, if I don't go with a letter from a mediator saying it's not suitable for mediation, do I run a cost risk and the displeasure of a judge? So Maria, well, how would the courts look at that?
No, generally no. So the applications made nowadays, the application can be made on the online portal, and actually during COVID and post-COVID, it's highly likely that most applications will be made through the online government portal. And so whereas there used to be a box ticking exercise on a form, you now go through the online process and it takes you to the next in each page. And you go through whether or not you've had a mediator, and if so, the details of the mediator, including their number and the date they would have signed your mediation form or your MIAM, or else you tick one of the, or you put a cross in one of the exemptions. So if you haven't got a mediator saying it's not suitable, you'd need to tick one of the boxes which says that you fall within the exemptions. Those exemptions can include urgency, they can include domestic abuse, they can include that you've been through mediation before and it wasn't successful, or it can include that you live outside the jurisdiction. Generally, most people will come under one of the exceptions, and if you don't, then perhaps you should be going to mediator. But the reality is that once you've checked the box and the court have accepted that you come within one of the exemptions, or else you've been through a mediator, and then your application is allowed to go through the process and it's issued after you paid its fee, there won't be then any comeback. The cost rules start from the presumption that each parent or each party to an application should bear their own costs. And it's only where there is evidence of poor litigation conduct. That's the terminology we use. In other words, you've acted really appallingly during the litigation, and the court then may express its displeasure with the other person's litigation conduct by making a cost order. But it's really rare, very rare.
Okay. All right, that's great, thank you. Okay, well, I'm conscious of the time. Hopefully on the screen in a moment will appear all of our contact details. As I said earlier, if you've got any questions, then please do feel free to contact us directly. And the poll should also be there. If you want to have a confidential chat, that's another easy way to make contact with us. So thank you everybody, all the panelists, for joining us today. I think an interesting discussion with everything that's going on right now. This will be recorded and will be available on our YouTube channel and other sources as well. So I look forward to seeing you again on our next webinar, and thank you and have a good day.